versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle, and Article 10(2)(a) of the Constitution. And this is what they say. This dual role is unlawful and unconstitutional. I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at, Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Genz, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House. That is the beginning of this problem. And so when Parliament embarks on a public participation process, it is incumbent on it to first advise itself of this history, that this man has been impeached because he made a statement in support of people who occupied Parliament. And so what do? And they concede public participation is necessary. My good friend Mr. Swanya will come and address us a bit more on this, but they give Kenyans 2 days to give public participation. When this court retires to look at the report, because what they did, they then collated, they issued forms. These forms had no serial number. These forms had no way of being verified whether these are Kenyans filling them or not. These were just forms that were distributed all over the place. But they then form a report. And when you look at the executive summary of this report, they say that they received 200,000 responses from the whole country. I did a bit of mathematics. 200,000 people as a function of the 14 million people who voted for the first petitioner and his president comes to 0.014 of the voters. Those are the people who participated. Now, I did a bit of maths in A-level. When you round off 4, it becomes 0. When you round off 1, it becomes 0. So there was 0 public participation, mathematically. It's that simple. 200,000 people out of 14 million is 0. A bit like the result I'm about to give you here on account of their compliance with the law. So you have 0%, and these are figures they themselves have given. In the executive summary, they list 10 problems they had with this public participation. They say there was very poor turnout. In one case, I think it was somewhere in KU, 168% people turned out to give their opinion. 68% spirits showed up to give their views in one particular case. And an order was actually issued against this process on that account. They then, in this form, list the allegations against the Deputy President. This is the National Assembly. But then don't give the people what the Deputy President's responses are. And this is not an idle issue I am raising here, because, as I stated, and under the Fair Administrative Action Act, Section 5, they must give the public the opportunity to consider all relevant material. All relevant material cannot include the plaint, but not the defense. That was a fundamental dereliction under Article 50 and under the Fair Administrative Action Act. They then say, based on these forms of theirs, that from the entire country, all 50 million of us, they received 8 written memorandum. 8. There are 41 petitioners before you this morning. There are more petitioners here than the number of memorandum they received. 8 of them. 1 per province. Kenya used to have 8 provinces. So again, on average, we got 1 memorandum per province of Kenya. That is what we call insufficient, inadequate, unreasonable, unlawful, unconstitutional. One of the other criteria the court is to look into is, and I think I should point out at this point here again, reasonable opportunity of being heard, which you will find is one of the criteria. I won't say much about it. Senior counsel has dwelt at length about it. The Senate is informed that the Deputy President is unwell. They even ask senior counsel, it's part of the Hansard, to convey quick recovery to him. It's actually there. They tell him, go tell him to recover quickly. Pray for him. They then say, but while you're praying for him, we will proceed here to hang him as you're praying for him. This is what they did. Now, how are we ever going to face Kenyans? By telling them this is what a fair hearing in Kenya looks like. As we are praying for you, we are slaughtering you here. We are praying for you with one hand, slaughtering you with the left. How are we ever going to face Kenyans and tell them that is the kind of justice we practice in this country? How are we ever going to tell them that is what Article 50 as regards a fair hearing means? One of the other criteria is that did the decision maker omit or fail to take into account a critical issue, or did they omit a condition prescribing the power they are to follow? My good friend Mr. Dudley here again has talked about the Senate proceeding to vote without appointing a special committee. The court has enough material on that, but The courts, and I say so with tremendous respect, will also have time to look at what the Supreme Court said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice, goon justice. They said, do a committee. You'll have time to look at that. I've said they did not conduct a constitutionally compliant public participation exercise. And as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act. But again, my lords and your ladyship will have time to look at the BAT case, again the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. One, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango-Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election, it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later, again because there just isn't sufficient time. And so, why the National Assembly and the Supreme Court in 2022 in its judgment actually said we ought to amend the Constitution to provide for more time, you know? Now, why the National Assembly, which has been asked this, and in fact, in 2022, the Supreme Court said this judgment should be served on the National Assembly for them to remedy this question. Both National Assembly and Senate did not take into account Article 50 on the fair hearing requirements. They did not take into account Article 94(4) of the Constitution, which requires them to protect the Constitution and promote the democratic governance of the Republic.